under common law, aren't you liable for the fraud of an agent or partner?
Yes, that is absolutely the liability rule, but it is not the rule that necessarily gets ported into federal statutes all the time. Vicarious liability is not a universal principle that just because you see a common law term or just because even Congress creates a tort, which again, it's not doing here, you don't just read in vicarious liability across the code.
Let's look at our decision in Husky. The debtor, you're saying it has to be the debtor's fraud that counts only. But in Husky, that case involved fraud by a third party, a shareholder, who fraudulently conveyed assets of the debtor company. We held that the debt was not dischargeable, even though the debtor made no misrepresentations to the creditor. The company didn't. The shareholder, an individual, did. But we viewed the company as bound by its agents. So isn't that a federal rule that we announced there on dischargeability?
No, and I think
what fraud means?
Husky announced what fraud meant as a matter of common law and said fraudulent conveyance is a form of fraud. Husky did not say just because you have a corporation and an agent and the agents actually—
Well, it did, because it made that debt not dischargeable. And the debtor wasn't the one who did the fraud, it was a shareholder.
Right, but for corporations, I don't think just because a corporation can only act through their agents, it means that you read vicarious—
Well, usually a shareholder is not considered an agent of the corporation. Its officers and employees are. So we took that principle even a step further than—
Respectfully, Husky does not expressly say anything with respect to imputation, and the things that it does say with respect to contrasting A2A and other provisions of the code make it very curious that if there was an imputation holding, it was not discussed. For instance, when the court is discussing the relative breadth or narrowness of A2A for fraud, A4 for defalcation, A6 for willful and malicious injury to property, and the 727 total bars to discharge.
All right, may I just finish a thought that in answering questions earlier? Have you abandoned the argument that a debtor is responsible for fraud he or she knew or should have known?
That is part of the argument, but it's necessary but not sufficient to our argument. So we are saying the debtor must actually have committed the fraud, him or herself. That is consistent with the question.
But how about if the debtor, if she knew that her husband was lying?
Yes, and if you knew that the husband was committing fraud?
Yes, if she knew that the husband was lying.
Yes, and that just gets back to the colloquy with respect to, do you have other indications that would suffice to be direct liability?
Why do you need more? Meaning, if they were partners and the form she signed said, I didn't commit any fraud, she signed a statement to the bank that said, I'm making all true statements. Not saying my husband is, but I'm making all true statements. She is not liable then?
No, in that situation, you would have given me a situation where if she knows that they're not true, she's making affirmative acts. That's clearly direct fraud. She's directly liable. And in addition to that, under principles of direct liability, the debtor would also be liable for encouraging fraud, for inducing fraud. If you have fraudulent intent, the next question is, what is the minimum amount of direct involvement to complete the elements of fraud? And again—
Thank you, counsel.